Welcome to Antitrust Code by Concurrences. Concurrences is the leading antitrust database with over 30,000 articles on competition law. Concurrences is also the largest network of antitrust experts with lawyers, economists, enforcers, and academics in 85 countries. By listening to this podcast, you will learn the fundamentals of competition law and hear about the latest antitrust news thanks to our guests, the best experts in the antitrust world.
Yes, hello, good morning. This is the OECD Concurrences podcast on leniency programs. I'm Despina Pachnou. I'm a competition expert with the competition division of the OECD, joined here by Maria Jaspers.
Hi, everyone. So indeed, I'm Maria Jaspers. I'm the director at the Cartel Directorate in the competition at the European Commission. So let's get started to debate this interesting topic. And maybe I throw the ball back to you first, Despina. I know that cartels and leniency are areas that the OECD has followed very closely for many years. So maybe you can start by giving us a bit of an overview of the most recent work and what you have concluded and can observe in that context.
Yes, indeed. We work a lot on statistics. In fact, we have an annual publication called OECD Competition Trends, which I encourage listeners to look up. I'll take through some statistics on leniency, but just to say, to begin with, that the adoption of leniency programs is, in our view, the major competition enforcement development of the last 25 years. To know that almost all countries have a leniency program now, as compared to 6 jurisdictions that had a leniency program in the year 2000, just 25 years ago. So I mentioned that we have statistics and we collect also statistics on leniency. So what we have observed is that leniency applications after a short period of decline are now increasing, and in a sample of, if I'm not mistaken, 47 jurisdictions that we looked in 2023, our most recent statistics, there were 383 leniency applications overall, which is the highest number since 2016, which shows that numbers are increasing. Before turning to you, Maria, just to say, if you wanted to read more on leniency, please check the Compendium of International Cartels, which has been edited by the OECD, published by Concurrences a few months ago. This is a collection of OECD papers of our research on cartels and on leniency. It includes our recommendations, our best practices, our policy views. It points to our own recommendation on action against hardcore cartels, and has a chapter of leniency. So, turning to an enforcer now. Maria, can you please share your experience in DG Comp with leniency, including what to do when you design or operate a program?
So that's a good start. Thank you, Despina. So indeed, just to build on that one, it's clear that it's not a secret that the Commission's leniency program has been tremendously important in our fight against cartels. And it's still a key tool for us to not only detect new cartels, but also to find the evidence that we need to bring the cartel to an end. And I think it's also clear to everyone that a well-functioning leniency program has a deterrent effect in itself, because it shows that no cartelist can be safe, and they can always have to fear that one of them will alert the authorities. But it's also clear that leniency would only work if the parties believe that they are better off in cooperating with the authorities. And for that one, we need 2 things. You need to have a program that is sufficiently attractive, and you also need to show that you can generate cases outside the leniency regime. So we at the European Commission have changed our program twice already in order to ensure that it is well calibrated to the environment that we operate in. And the current program is from 2006, and we have so far received almost 600 applications under that program. I think personally that there are 2 key factors that one has to pay attention to, both in the design but also in the day-to-day operation of a leniency program. And that is predictability and trust. And this can not only be nice catchphrases, but the applicants must know what we expect from them and what they can expect in return. At the European Commission, we make a big difference between the first successful applicant that can get full immunity from fines and subsequent applicants that we put in fixed leniency bands depending on when they come forward. And then we decide the precise reduction within that fixed band depending on the evidence and the cooperation that they bring. But the second applicant can maximum get a 50% reduction, which is a big gap for full compared to full immunity. I think it's clear from our published decision that we are usually quite generous in our fine reductions to leniency applicants, provided that they give us full and sincere cooperation from the beginning until the end, because that is also part of the predictability and trust. Our program sets out very clearly what types of obligations and conditions that the applicants must satisfy. And one of them is that they have to provide a corporate statement where they describe the cartel. What did it involve? How did it operate? Which companies participated in the cartel, etc. And contrary to many jurisdictions, we don't use these statements simply to navigate our investigation, but the court has confirmed that we can use them as direct evidence. And I think that is particularly important at this moment in time, because we are being confronted with novel forms of cartels that are organized in a different way, and they do not necessarily leave behind the same amount of self-explanatory contemporaneous evidence that we may have seen in the past. So I think this is an important factor for our program. It shows that leniency can deliver also when we work with new types of cartels and new types of cartel setups. So since leniency is such an important part, then of course we started getting a little bit nervous a few years ago when we saw a sharp and consistent decline in the number of applications since notably 2015. I think there are many factors that play a role when a company decides to come forward and cooperate with the authorities. And I think those factors, including their individual relevance, they are not static. They can change with time, and they vary between different jurisdictions. Turn that trend around, and we now have consecutive year-on-year increased numbers, and that is, of course, quite reassuring. So we're now at this point where we have a stable number of new applications coming in, generating interesting cases. But we have also learned our lesson. And one of them is that we should not be overly dependent on our leniency program. So we also have to make sure that we can develop an active ex officio portfolio built on our own intelligence cases. And we're very relieved to see that also when we start investigations outside the leniency regime, we get leniency applications thereafter. And sometimes there is even a clear race where applicants come in with only a day or even a few hours. So that being said, what can you share in terms of the observations of the general trends in leniency?
So yeah, as I've said before, we do monitor numbers, and we have observed the same trend and the age of the leniency program. So leniency programs may take some time before they are used and become useful, and we looked into that. And likely it's due to different reasons. One explanation, and you mentioned it, could be that the leniency program is a victim of its own success. So when authorities rely more on the leniency program because it is successful and engage less in proactive detection, they thereby decrease the threat of detection and therefore lower incentives to apply for leniency. So it's a circle. Also, we have observed, but this may be more relevant outside the EU, that generous cartel settlements after the case has opened may also lower incentives to apply for leniency. So if this expected fine reduction via settlement is generous, then in some cases, companies wait and see. It's a strategy. They wait for the authority to open a case against them first, and only then, and based on the strength of the case and their communications with our counsel, decide whether to cooperate and settle and obtain a fine reduction in countries where fine reductions are very high. I mean, I could go on, but I don't want to take more time. I'd like to mention something that is often mentioned. It's often said that private enforcement may lower incentives to apply for leniency. And it's true that leniency applicants do run the risk of being sued for damages since the competition authority's decision is final against them, and this may make them the first target for cartel damages. But since you asked about our observations, well, our observations are that leniency declines and increases are to an extent independent of the success or the operation of the private enforcement system. So, for example, we've seen leniency numbers rising, but we haven't seen private enforcement changes. So the correlation, at least the obvious correlation, is not there. May I add that the OECD recommendation on fighting bid rigging in public procurement, which is one of our recommendations, does advise to consider exempting the successful first in leniency applicant from damages claim. Consider exempting is a soft language which says basically take into account your whole system and proceed accordingly. And one last thing, I talked a lot about decreases, declines. What about increases? Well, traditionally, and you said it very well, increases of leniency application happens when there is a high detection threat through the authority's own initiatives, and also when the potential fines are high. So there is not a good business case to continue with a cartel, but rather a good business case to apply for leniency. And I end with saying, yes, you said it, ex officio investigations, very important for the continued success of leniency itself. So based on your insights and based on your and Digicom's experience, how can one improve a leniency program?
Well, thank you. And I found what you said was very interesting there, Despina. Just one last comment a little bit on the statistics, that a high number of leniency application has, of course, a value in itself because it shows that your program is attractive. It shows that you have broken the trust between the cartelists, that none of them would alert the authorities. But naked statistics and curves do not really tell you a lot about how effective your program ultimately is. We in the Commission, we have had years when we started the same number of investigations based on 12 applications as we did in years when we received more than 60 applications. I think the decisive question that one should ask itself is really, do we manage to get the applications for the type of cases that we are particularly interested in moving forward at this juncture? And as far as the European Commission is concerned, the reply to that one is nowadays clearly yes. But now going back to your question, I think there are two main reasons why we have managed to turn around this declining trend in leniency applications, and we have touched upon them already. The first one is that we have really made visible investments to make our program as attractive as possible. And the second one is that we have also done visible investment in our ex officio activities, so in our own intelligence-driven activities, to show that we can both find but also conclude cases without leniency applicants. But if we start on the first one, which might be most interesting in terms of the design and day-to-day implementation of leniency programs, we had a very useful debate with legal and business representatives about 3 years ago to better understand how they perceived our program. And immediately thereafter, we followed up with some initiatives that were brought up in that context. And that including publishing FAQs, frequently asked questions, that better clarified our policy, but also our practice. And it also clarified that there can be advantages besides leniency reductions to leniency. So besides fine reductions to leniency applicants. And you mentioned it already, Despina. For instance, that leniency applicants can possibly be exempted from a public procurement ban, which is quite important in certain sectors. Another thing that we have implemented more recently that I think has also contributed to an increase in leniency is that we put in place practical arrangements to assist applicants in the early stages. And that includes appointing dedicated leniency officers. So their role is really to be the first point of contact and be the public face of our program towards the outside. That ensures consistency, but it also ensures that you can have discussions with them even on a no-name basis. We understand that companies are sometimes hesitating a bit on whether a certain conduct would actually constitute a cartel and whether they can actually benefit from the leniency program. So introducing these no-name basis discussions to have that dialogue with our leniency officers have been very well received and very helpful. And last but not least, in terms of practical arrangement, we have also facilitated the filing of leniency applications by introducing already a while ago an online platform that we called e-leniency that is available 24/7, which allows the applicants to upload their applications and the supporting documents, but also for us to communicate and share sensitive information with them in a fully protected environment. And that has reduced cost and time for the parties and for us, and made sure that we're a little bit more accessible. But as I said, to create the right intensive and to create really the race for leniency, you also have to visibly show what the counterfactual would be. And that's why I would strongly advise all agencies to also continue to invest in intelligence-driven ex officio investigation. Today, half of the cases in our cartel portfolio are ex officio investigation, and many of the recent downloads that we have carried out were triggered by whistleblower informants or our own screening and monitoring activities. And we intend to keep this half-half mixture, even now that we are getting leniency applications coming in again. Because it is important that we do not become overly dependent on our program. And it's reassuring to see, as I said before, that we also get leniency applications in those cases that are started as ex officio cases. Our program foresees that you can get immunity even after we have taken the first investigative steps. But the threshold to get that is typically much, much higher. We simply do not want to foster the wait and see if they catch us attitude that you alluded to there, Despina. So companies should come forward quickly. If they miss that opportunity, then they have to know that immunity might very likely be off the table. And I think that's why ex officio has not only increased the detection risk for cartels, but they have also made companies realize that they lose the full benefits of the leniency program if they simply approach us too late. So to sum up on this one on my side, I think as a cartel fighter, it's of course very reassuring to see that leniency is back on track at the European Commission. It's generating new interesting cases, and it also allows us to find the evidence that we need to actually punish the cartelists. We certainly value very much the discussions that we're having with other enforcers, including in the context of the OECD. These discussions are enormously important for us to share our insight and experience and learn from others. And we also very much value the discussions that we're having with the legal and competition communities to also see how we can overcome any hesitation to cooperate with us under leniency. We have an obvious interest to make sure that our leniency program remains attractive.
Well, thank you very much. I think there is a lot more to be said, but I think for the purpose of this podcast and not to tire listeners, we conclude this. But let me take this opportunity, since I have now the space, to say that a lot of our work, almost all of our work, both for Digicom and the EU in general, as well as the OECD, is online. So do check our web pages. All the research I referred to, all recommendations online, likewise for Digicom's webpage, which I consult frequently. Also, you can find the Compendium of International Cartels I just mentioned, which is basically a compilation of things we've done in the past on cartels. So with that, I conclude the discussion. Thank you very much, Maria. Very interesting. And we'll be watching this space, as we say.
Indeed. Thanks a lot.
You listened to an episode of Antitrust Code by Concurrences. If you want to read more about this topic, check the Concurrences website where you can find all relevant articles. Follow us on Twitter @CompetitionLaws and join the Concurrences group on LinkedIn to receive updates on our next podcast.